to their homes in Oregon, and they're not here, which is a detriment to them. They had as much a right to be here as she did for sentencing.
All right, guys, this one's a bit different today. We have got a sovereign citizen who just won't stop talking and seems to think she's above the law throughout the entire hearing. She keeps interrupting the judge and going off on the officers as if that is somehow going to win her case. Spoiler alert, it does not. The best part, the judge is not having any of it. This guy is all business, no patience. By the end, he hands down a brutal sentence. She clearly did not see coming. It's honestly a masterclass in shutting down nonsense. Let's dive in and watch this sovereign citizen get completely wrecked in court. And while we're at it, drop your guesses in the comments. What do you think her IQ is? Because I've got a feeling it's way below room temperature.
No, come on out. This is the date and time set for sentencing. The records show the presence of the defendant. Our advisory counsel is here. And Mr. Wagner, are you appearing before the state?
Yes.
This is the date and time set for sentencing. Good.
Excuse me, how you doing?
No, I'm talking now. Listen to me. Is your true name and your complete name Shayna Marie Blackshire?
The court lacks jurisdiction over subject matter.
What is your date of birth?
The court lacks jurisdiction over the subject matter.
The court will accept the court, based upon a verdict by the guilty in this case.
The court lacks jurisdiction over personal addiction.
As a result of a jury trial, the court finds the defendant is guilty in CR 22209. Count 1, unlawful flight from a law enforcement vehicle, a Class 5 felony. This is in violation of ARS 28624C,
Y'all cannot force me to get sentenced.
Yes, I can. ARS 28622, ARS 28622.01, A1, 28624C, 283001, 283304, 283305, 283315, 13701, 702, and 801. The date of the offense was on or about February 5th, 2022. The offense is non-dangerous, and I'm finding it non-repetitive for reasons I'll state on the record. Count three, that she is guilty of count 3, criminal damage, a Class 1 misdemeanor. It's in violation of ARS 13-1602A1, 13-1601, 13-707, 13-802. And she's also guilty of count 4, burglary in the second degree. This is a Class 3 felony in violation of ARS 13-1507A, 13-1501, 701, and 702, and 13-801. The date of the offense was on or about February 5th, 2022. Judgment of the court that she's guilty of count 5, resisting arrest, a Class 6 felony in violation of ARS 13-2508, A1, 13-701, 702, and 13-801. The date of the offense was on or about February 5, 2020.
Why is it allowed to do such things?
2022. The offenses are non-dangerous and non-repetitive. The reason I'm finding them is the microphone off, Louis, by the way. I'll turn it off.
That's illegal. Y'all can't do that.
No, that's on now. Turn it off.
Yes, it is, Justice.
All right.
This is exactly what happens when someone who thinks the world revolves around them finally gets hit with a dose of reality. This sovereign citizen is clearly the victim in her own mind. There is no question about that. You can just tell she's been like this her whole life, judging by the sheer audacity she is giving off. Who walks into court, yells at the judge, and talks over them like it's no big deal. No normal person would do that, especially when facing years in prison. And let's be honest, nobody just wakes up one day and decides, yep, I'm going to deny all laws and social norms for fun. Nah, this level of delusion took years to develop, if I had to guess. And this is just my opinion. She probably grew up without a father. Now, I'm not here to diagnose people over the internet. But let's be real. This is peak dad left for milk and never came back behavior. Tell me I'm wrong. Let me know what you guys think, agree or disagree, because I have got a feeling I'm spot on with this one.
So, the offenses are non-dangerous. I'm finding them I'm finding you're your own lawyer. He's not your lawyer. He's nothing can do it. I'm finding that they're non-repetitive because I believe that these cases, all of the charges in this case and in CR 2022-208, which is the prior case for which the defendant was convicted, these cases all those charges could have been brought together and tried together, but they weren't. I'm not criticizing the decision. It is what it is. It happened for independent reasons, but I'm finding that they are not repetitive. All right. So, Mr. Wagner, do you want to be heard on behalf of the state?
I do, Your Honor.
And if the victims wish to be heard, we have victims here in the courtroom, a victim, I think, I'm not sure.
No, Your Honor, she's outlasted the victims.
She's outlasted the victim. Do you wish to be heard?
The victims have had to return back to their homes in Oregon, and they're not here, which is a detriment to them. They had as much a right to be here as she did for sentencing, but she is her own attorney, and she's drugged us out long enough that the victims aren't here to give a statement today.
Right, so y'all can't do that. Y'all cannot force me. Y'all can't vicious me like this.
Ms. Blackshire, I believe that these are repetitive and that she should be subject to the Category 2 repetitive offender statutes. She committed these crimes. She was taken into custody for the first crimes, the 208, Your Honor. She was taken into custody for 208. She made bond and was released on bond. And then she committed these separate offenses while on felony pretrial release.
I just want to make clear, to save your words, I do intend to impose the enhancement of 2 years for the crimes being committed while on release. So I just want to...
All right, thank you.
If there's any confusion about that, I wanted to straighten it out. I apologize for interrupting you, but I thought it was something to clarify up front.
This is illegal!
I believe that it's more than warranted. She was sentenced. Those were separate cases. She was released from those cases, and she committed the new cases. Not only did she commit these crimes separately from the other crimes, these crimes significantly, especially the burglary, I believe substantially affected the victim. The victim, the owner of the property at Morningstar Ranch. Yes, she was burglarized before. No real property was taken from there. As you heard, you sat through both trials. But in this case, in this burglary here, count... Count 4, Your Honor. The defendant confronted the victim at her home and has substantially affected the way the victim feels about her safety and security at the home, which I think is very important, Your Honor, to acknowledge that.
I'm sorry. I'm getting... What's that?
Are you going to allow
No, I'm talking to you. Why are you taking her up? You're not? Okay.
But I don't want to be in here.
Staying in. Oh, you're bringing the chair in. Okay, that's fine. I apologize, Mr.
That's fine, Your Honor.
I was getting signals from the defense.
That's fine. I also would point out to the court that the unlawful flight from law enforcement...
Stand by. Apparently they're going to restrain her and bring her back in. Thank you. All right. All right. Defendant is back. You may continue, Mr. Wagner.
Thank you, Your Honor. I would also point out to the court that count 1, the unlawful flight from law enforcement, and count 5, the resisting arrest counts, are not in any way connected with the prior the 208 case. They're separate victims there. These are definitely separate incidents. The state would argue that as well for count 4, the burglary, Your Honor.
No, I'm not backing up. This is illegal. The court lacks jurisdiction over the subject matter. Y'all don't have no right. Get this shit off of me.
Get this off of you, girl. Maybe if you were not acting like a 4-year-old who just got their Mickey Mouse privileges revoked, you would not be strapped into that chair like a full-blown maniac. And when I say like a maniac, I am not saying she is not one, because at this point she pretty much is just look at her. If there were ever a psychological study on sovereign citizens, she'd be the cover photo. Honestly, I would not even be surprised if she started the whole movement, but the wildest part she is. Out here, wasting the time of 7 officers, 7, that is half the police department, babysitting this walking headache. While actual crimes are happening, someone's probably getting their car stolen across town. But nope, all hands on deck for Queen Delusion. Honestly, they should send her a bill for all the wasted resources. It probably costs more than the fake diplomatic immunity card she bought off Facebook. You can just see how done the officers are with her nonsense, but they have got the patience. Of saints, if I were them, I'd be asking for a raise after dealing with this absolute circus act.
If I could have just a second, Your Honor.
I ain't never been fighting with y'all.
What's the statutory reference to the 2-year enhancement? I can't remember that.
It is, I'm sorry, Your Honor, it is 708D, and I don't know that I made that entirely clear, but it just, whatever the sentence, the court prescribes, each sentence gets a 2-year enhancement.
Is that ARS 13-7?
Yes, I'm sorry, ARS 13708.
But not as to the misdemeanor, obviously.
Not as to the misdemeanor. I concur with the misdemeanor assessment that probation had, that it's just time served in the county jail, that she's already fulfilled more than the requirement for that. I agree that the presumptive terms are warranted in the other cases as well, Your Honor. I would point out that the jury during the aggravation phase, the jury found 4 aggravators. They found 4 aggravators. We have no mitigators here that I can see. Even with all of that, I would still ask for the presumptive terms as a Category 2 repetitive offender with the enhancements for the 13708D. I think that these charges probably would be warranted to run concurrent with each other, but I do feel that they should run consecutive to the defendant's prior case. She caused more harm and more emotional stress to the victim, the owner of the property, and then we have separate victims as to the resisting arrest charge and the fleeing from law enforcement charge, Your Honor. I don't have anything more to add than that, and there's no victim's presence. There's some representatives, some neighbors, some people from the Morningstar Ranch that are still living in the area. They're present here today just to watch, I suppose.
Very well. Thank you very much. All right, the court imposes a sentence as follows. As to count 1, unlawful flight, a Class 5 felony, the court, as I said, finds the offense to be non-repetitive, non-dangerous. The court imposes the presumptive term of 1.5 years in the Arizona Department of Corrections. The court imposes an additional 2 years sentencing enhancement because this offense was committed while the defendant was on pretrial release, and that's pursuant to ARS 13708D. So the total sentence as to count 1, Class 5 felony, is 3.5 years. As to count 2, this is the misdemeanor criminal damage. The court imposes a sentence of time served. As to count 4, again, the court finds this to be non-dangerous and non-repetitive. This is burglary in the 2nd degree, Class 3 felony. The court imposes the presumptive term of 3.5 years. The court also imposes the sentencing enhancement pursuant to 13708D of 2 years. So the total offense level, the total sentence for count 4 is 5.5 years. As to count 5, resisting arrest, it's a Class 6 felony, non-dangerous, non-repetitive. The court imposes the presumptive sentence of 1 year. The court further imposes the sentencing enhancement as required by law under ARS 13708D for 2 years, for a total of 3 years as to count 5.
If you enjoy this kind of content, do not forget to hit that like button and subscribe to the channel. It really helps me out a ton. All right, let's jump back into the video.
The court further designates that the sentence imposed on counts 1 and 5 are to run concurrent with each other. That is the unlawful flight and the resisting arrest. The sentences in counts 1 and 5 are to run concurrent with each other. The sentence imposes on counts 1 and 5 are to run consecutive to the sentence imposed on count 4, which was 5.5 years as to burglary in the 2nd degree. So the sentence imposed on counts 1 and 5 is to run consecutive to count 4. The court imposes The sentence imposed on count 4 in this case, which is burglary in the second degree of 5.5 years, is to run consecutive to the sentence that was imposed in case number CR 22208. Right, so the sentence imposed as to count 4 in this particular case is to run consecutive to the sentence imposed in case number CR 22208. That's because this defendant was released in the prior case, 22208, when it was a justice court case. She was released when she posted bond on July 7th, 2021. She failed to appear and a warrant was issued for her arrest on October 20th, 2021. The events in this particular case are alleged to have occurred, I believe, on February 5th, 2022. So the events that happened at the Morningstar Ranch that were the subject of 22208, do you wish to have an attorney appointed to represent you on the appeal? If you cannot afford to pay one, the court will pay the cost of an attorney to represent you on appeal. That will include the cost of the lawyer's legal fees and legal costs. You will not have to pay anything. Do you wish to have an attorney appointed to represent you on the appeal? No. Appeals are specialized actions, and Court of Appeals is very sticky with their rules. They're very strict, and it's a real specialty with someone who knows how to write good appeals. I met with you before when you were here before, and we met not in chambers, but in the holding cell area. It's all on the record, what I'm referring to, and I advised you that it really is in your best interest, I believe, to have a lawyer represent you on appeal, and you indicated at that time that you don't want a lawyer to represent you on appeal. I really encourage you to do it. I think it's in your best interest, but it's your choice. Okay. You're excused. You're remanded to the custody of the sheriff to be delivered to the Arizona Department of Corrections to fulfill a sentence. What? Hold on a second. What?
How much time did he give me? You said a whole bunch of numbers.
Yeah, you can take them. You're excused. Thank you. Good luck. All right. I'm not having the defendant step forward to sign for notification of her rights and to sign the judgment in this particular case. She's consistently, throughout all the proceedings in the Justice Court and in this court, as to whenever required to do so or asked to do so, refused to sign anything. So that would be fruitless to ask her to do that. But the record will reflect that I've advised her of her right to appeal, the right to have an attorney represent her on appeal, and I think that's all we're going to do. And I don't see any point in having her trying to sign these documents. That's just not going to happen.
I don't.
I think it'd just be disruptive to the court proceedings. Okay. Anything else? All right, we're adjourned. Thank you all very much.
You know what is crazy at this point? Seeing a new sovereign citizen pop up is not even surprising anymore. It's like every single day, there's another video of some self-proclaimed free inhabitants screaming about maritime law while getting dragged away in cuffs. And honestly, a lot of this nonsense comes from the downward spiral of politics and the breakdown of families. Let me know if you guys agree. But if we're being real, half of these people probably grew up watching YouTube conspiracy videos. Instead of having a father figure to teach them basic life skills like, oh, I do not know following the law now, they are out here thinking they can just declare independence from reality and dodge consequences. Spoiler alert. They can't sovereign citizen logic hold about as much weight in court as a Monopoly get out of jail free card actually scratch that the Monopoly card might be more convincing than the nonsense they spew. And if you have ever wondered whether sovereign citizen arguments hold up in court, let me save you the suspense. They do not, like ever judges have repeatedly ruled, that claims of diplomatic immunity, straw man theories, or rejecting citizenship are legally meaningless. What these people are doing is basically legal Jenga, pulling random blocks of nonsense until the whole thing collapses on their heads. But yeah, guys, I really want to hear your thoughts on this one. It was honestly insane, and I have not seen anyone act like this in court in a long time. Drop your thoughts in the comments. Love reading them. But that is it for this one. Take care, and I'll see you in the next video.